Good evening. You are listening to the Veterans Voice here on 790 KABC. This is Amanda Manier. I am a veteran advocate and a managing attorney at the Veterans Law Group who sponsors the show. And what we do is we help veterans kind of navigate the process of working with the VA, veterans and their families, to get their VA disability benefits. So one of the joys of my job is I get to host this show. We are live this evening. This Veterans Voice is all about being able to answer your questions when it comes to VA disability claims. Sometimes when we'll have a guest along with us to talk about an organization maybe that's helping veterans, or sometimes just talking about things that are happening in the community of the veterans, new laws that are coming up to pass, times when you need to call your senator, your congressman. That happens at times. Again, we are live here this evening. We're welcome to take your calls of anything you would like to talk about and how it affects veterans and their families. 800-222-5222 is our number here. Again, I'd be happy to take calls specifically related to your disability claim or a family member's. If you're not comfortable with talking about it straightforward online, you can always submit, or online meaning live here on the show, you can always submit a question on our Facebook, Twitter, or Instagram accounts. We also have a YouTube channel if you search veteranslaw.com. You'll find a lot of helpful resources in there. Hear a little bit of stories from some of our clients, and then also be able to submit questions. I've got a few questions here this evening that I would love to address, but I will also, generally when I start a show like this, I have a couple of topics of conversation that I just kind of get things started. But if there's anything that is, you're welcome to call if it's outside of the topic of what we're talking about. So just feel free to do that. Again, our number here is 800-222-5222. Me and my team have been doing this for about, founder of our organization over 25 years. It's exclusively all we do. So while I don't know a whole lot about things like the GI Bill or litigation or family law, those kind of things, I have a very in-depth knowledge of VA disability claims, and I do my best to try to simplify what can be a complicated process. I would like to say it's not always a complicated process as much a frustrating process. That I understand that the VA just, there's mounds of paperwork that not only comes from the VA, but making sure you get things on the right forms and submit them to the right place. And, you know, if you're one of the veterans who's been with us for a while, Vietnam veteran, or even we've worked with some World War II veterans, you might know the history of, prior to about 2015, a veteran was able to file a claim in any way, shape, or form. They could call the VA and say, I think I hurt my back while I was in the service, or I think I'm struggling with mental health issues, and that would start the trigger of a claim with the VA. And over time, I always kind of joke about you could write it on a napkin and fold it up and hand it to somebody at the VA. But over time, it's definitely become a lot more complicated in the sense that they started with requiring forms, their particular forms. And now it's even come to a point that there's multiple forms, and you have to make sure that you pick the right one in order to get your claim started. Or you'll often get a letter that says from the VA, you submitted your claim on the wrong form, please submit the right form. But sometimes they don't tell you what that form is. So it can become, and it has become over time, more frustrating, I would say, more than complicated. I guess it is complicated in the sense of finding the right form to submit. But my advice always to any veteran who's originally filing a claim is to never do it alone. That doesn't mean you have to work with our office. Our office works only in appeals, which means that if you have a VA disability claim, you've filed it, you've received a decision, and you're trying to figure out what to do next, that's the point at which we can help you. If you're initially filing a claim, my recommendation is always to work with a county veteran service officer or a service officer at the VFW or DAV. They all have them. Los Angeles County has them. They have some great ones that I know relatively well. So feel free to reach out to them and get your claim started, get your claim filed. Some VSOs handle appeals, some don't, but you got to get the process started. And I've had a conversation with somebody the other day about, well, should I wait till I have all of my evidence together before I even file a claim? And in his particular case, I was, indicating to him that it was going to take a while for him to get some of the medical records that he needed and that kind of thing. And there's multiple ways, there's an intent to file if you've never filed a claim before. There's get the file started, and then they will give you time to get your evidence in. They'll give you an opportunity. VA is required to do what is known in the industry as duty to assist, which means that they're required to ask you if you have any more records. They're required to get you a CNP exam if you meet certain qualifications. So get the process started. Take it bite-sized at a time if you can. That's usually my recommendation. Different people feel different ways, but that's usually my recommendation. Again, we're live here this evening. If you'd like to join us, this is Amanda with the Veterans Voice, and we're talking about all things related to veterans' disability claims and dealing with the VA. Our number here is 800-222-5222. And we'd love to talk to you about your claim if you're a veteran or a family member, or if you're somebody who has some questions. Last week we talked quite a bit about some new legislation that's currently working its way through Congress. It's passed the House and it should go before the Senate. It is expected to pass. It has very high bipartisan support, which, as you can all imagine these days, is very rare. But when it comes to veterans, generally, politically, it's not a good thing to stand against that. So there's some good things that are, in the works and coming down the pipe, and we'll see what happens. But I do anticipate quite an influx in claims after that is passed, as there should be. There's a lot of things that are in that bill that have affected veterans going back to Vietnam era, who have been denied because of nuances in the law or little restrictions in the laws to who was exposed to Agent Orange, say when they were in Thailand or Guam or somewhere other than Vietnam, that most of us feel like has been disparaging to people who served in those areas that were likely exposed to Agent Orange. So there's some of that, and then there's the burn pits legislation that's coming through under that same act that's currently working its way through Congress. So there's going to be a lot that's going on. So I say all of that and reiterate that if you're interested, you can definitely go to the 790K ABC website, listen to last week, or go to our website at veteranslaw.com. It'll be posted under our podcast. But there's some good information in there and stuff that you should be aware of if you fit within some of those categories. But part of the reason why I bring that up now is with the idea of, should I wait to file my claim? I do generally, like I said, anticipate a wave of claims coming in. So if you've been sitting on a claim to file, I would highly, highly recommend you get your claim in. So let's talk about a couple of topics that I kind of threw out there that have come up. In one of the things that I do at our office is I've got a team of amazing paralegal who is a Air Force veteran. Her name is Star. She's been on this show a number of times with me co-hosting. Her and Karen, who is the wife of a Army veteran, spend all of their time helping to deal with work with lead calls or doing potential consults, potential client calls and consultations. So if you contact our office and are interested in representation, you're generally going to talk to one of them. They're amazing. They're very knowledgeable. And then I end up reviewing those cases. And because we work on contingency, we choose which cases that we take. It's hard to say no to clients or to potential clients. Sometimes it's about our workload level. And I feel like I have a handful of people that I refer veterans out to who are maybe better suited attorneys for them with their particular specialty. But I see a lot of cases that come in, veterans who are pursuing getting an increase in their claim, getting service connected. And so I've got a number of, each week I tend to have things that tend to be a hot topic. And this particular week, one of the hot topics and often things that were happening is two things. One is the VA that was denying a veteran for PTSD claim that was a non-combat related stressor. So we'll talk about that a little bit. And then the other thing is related to mental health that is separate from PTSD. So we talk a lot about PTSD, especially these days. A lot of people tend to associate PTSD with military and combat. Certainly if you're somebody who has, experienced trauma that is not in those categories, it's still continued PTSD or PTS. There's also a number of other mental health conditions that are definitely service connectable at the VA. And so I want to dig into that a little bit. So if you have any questions on either one of those conditions or either one of those scenarios or anything else related to VA disability that you want to talk about or you have questions about, again, we are live here this evening at 800-222-5222. The other thing that I want to address as well, so we get past that if we have time, is denials. So if the VA denies a service connection, say for a back condition or a knee or an ankle, and you had filed within a year of service, and I can see in your decision that the VA determined that you do have a diagnosis of a condition, but they're saying that there wasn't anything in your service treatment records in order to trigger an exam or to service connect it. And so there's some nuances there that we've been arguing successfully in getting those cases that are passed, that even if you don't have anything in your STRs and you file relatively soon after your time in service, we've been able to argue that. There's a lot of things that happen with working in the VA industry and working in VA disability where it's not necessarily the letter of the law, but you're able to make an argument and to convince especially a judge at the BVA, at the Board of Veteran Appeals, who tends to have more discretion to determine whether or not they consider lay evidence, which would be your story, your testimony under oath, credible, and with lack of medical evidence that can substitute for it. So I'll get into that a little bit if we have time. If not, we'll table it for a future call, but it's something that has definitely come up quite a bit. If you've been denied service connection, but you filed relatively soon after you got out of service and you have a diagnosis already, including degenerative disease or arthritis or something like that. So this is Amanda Veneer with the Veterans Voice. We are taking your calls live this evening. If you are a veteran or a family member of a veteran who is trying to work through the process of getting a VA disability claim granted, or would like to talk about some of the up-and-coming changes that are currently pending going through Congress that will have pretty much a huge effect, in my opinion, on what's happening with the VA. Enough that we are just talking with Diane, who is the Executive Director of NOVA, the National Organization of Veteran Advocates, of which we are a member. They are the membership organization for attorneys and claims agents who represent veterans before the VA. They keep us pretty much up to date on what's going on. They meet with people up on Capitol Hill and then the VA on a weekly and sometimes monthly basis about what's going on. And they are already ramping up, working on contracts for CNP examiner contractors, outsourcing some of that work, even some mobile examination facilities, expecting the PACT Act to pass. So that's pretty much how serious it is, and expecting it to pass probably within the next month or so. If you want a little more detail on what we were talking about last week, we dug into quite a bit. So I just wanted to reference that and then go on to some of our other topics. But I understand that we have Lieutenant Martin on the phone. Is there a topic you would like to talk with this evening?
Yeah, hi again. Wonderful. Sixth-time calling. And there's a reason why I call back, because you touch on such intricate, deep things that true veteran problems, and we really appreciate it. And so I have another unique one out there. It's a veteran whose father was a it's a dependent, and the father was a Vietnam vet, died posthumously, awarded 100%. The death certificate was diabetes related. So the Agent Orange on the Blue Water for 2 tours, love letters to the mother helped prove it, plus evaluations in the Navy. Well, anyway, the son is about 60 years old, and the father died 100% service connected, and the mother received the DIC for 10, 15 years. The question is, does the DIC apply to the children who are above, say, age 23, 26, above the TRICARE age, and if they're not in college, but they're unemployed and they're really having a challenge this late in their life? And then I'll hang up and listen to you. Thank you very much. Appreciate it.
Thank you. Thank you for calling in. You are somewhat speaking my language and about to get me on a soapbox, but I will try to curb myself a little bit. When it comes to adult children of veterans, unfortunately, there is restrictions that are some nuances in the law, of which I am currently working with my team on and a legislative initiative on to start working with some congressmen on it. We'll see how far it goes. I've never done anything like that, but like I said, I get a little bit on a soapbox about it. But in your case, particularly, Lieutenant Martin, unless it is a disabled child, no, there isn't benefits that are left over for them. I'm glad to hear that there was a spouse to be able to get the 100% disability, to get the DIC. And the legislative initiative that I'm talking about working on is a little bit different than that, but it is when a veteran dies and their case is still pending and there's accrued benefits there. Then accrued benefits, and specifically that I mean are, say a veteran had filed their claim. Well, I'll give you a real live example because what I'm currently working on and that inspired this legislative initiative on this is a veteran who had applied in, I believe it was 2010, 2011 for some orthopedic injuries related to an injury he had on the ship many years ago. But he sucked it up. He went about his life. He worked in cabinet making, all of that kind of thing, but always struggled with these shoulder injuries. Ultimately, one day got up and decided and realized that he couldn't work anymore. He couldn't lift his arms over his head anymore. So it took us a while because we had to go to the board and give his testimony about what happened to him on the ship because there wasn't enough documentation. And we were able to get him service connected for that, but they hadn't yet pursued his unemployability. Or not that the VA hadn't done development on it. We had it in the record that he was unemployable, but the VA now requires, as I was alluding to in our first segment, of the VA requires certain forms to be filled out and development to be done. So we did all of that. And while he was waiting for an examination, COVID happened. And it was relatively early on in COVID. And he ultimately, unfortunately, passed on during that time in September 11th of 2020 while he was waiting for the rest of his claim to go through. Now, unfortunately, he was not married and he didn't have adult children. And so, he didn't have, minor children, dependent children. And so because of that, because of some nuances in the law, then it doesn't allow anybody to step in as what they call a substitute claimant. So the VA has this argument that children are entitled to accrued benefits, but nobody is able to actually step in as a substitute claimant and continue to pursue that claim because he doesn't have dependent parents, dependent kids, or a spouse. So that's just, again, one of those nuances in the law, difference between the statute and the regulation that I believe should be changed. Because there's nothing that you can possibly say to convince me that he did not want that money to go to his kids. So with Lieutenant Colonel Martin's question about that particular scenario is that I would feel the same way, that they would want some benefits to go to their children, especially if they die early on. And so I'm looking at that particular legislative initiative a little bit different than what you were talking about, because there was somebody who did get some benefits, and that was his spouse. When it comes to Vietnam and Agent Orange, there's some very small, narrow periods of time, or not periods of time, but conditions that would pass on to a child. But it doesn't sound like with diabetes, it wouldn't be one of those. So again, something that is frustrating to me. It is, I don't think it's what was intended by the legislation, but I think that the way that the regulations were written is what's causing that problem. So that's the kind of thing that we work on. It's figuring out how do we affect change within the VA in ways in which we don't have to. I mean, it's a very, very, very simple change in the definition. It should be a one-page legislation. Now, we all know Congress and we all know the House and we all know that trying to get a one-page legislation through is probably going to take a big, pain in the butt. But I can't imagine a organization. I feel like all VSOs, VFW, DAV, they're all going to get behind it. NOVA would get behind it. So it's something that I'm currently working on with my team, and we'll see where it goes. But yeah, it's certainly a frustrating thing. So I hope what that wasn't really helpful to Lieutenant Colonel Martin. I know that, you were looking for a better answer, but right now the answer to that is there really isn't anything for the son that's left for that, unfortunately. So, again, we're live here this evening. If you've got another question or a comment or something you would like to chime in about with regards to veterans VA disability, you can ask specific questions or general ones. Our number here is 800-222-5222. And we started talking a little bit about some things that I have seen that have kind of been coming up in some of our potential clients and people who are calling our office and asking questions and looking for representation. There seems to be a wave, I think, sometimes of different topics. And this one in particular is related to, well, there's three of them. I think because of our time and we're coming up against a break, I'm going to dig into the one that might be the shorter period of time, and that's denials with diagnosis when you filed within 1 year of service. So in a rating decision, when you file a claim for, say, an initial claim, which is filed on a 526EZ, or you can file it on line 3 benefits, you file that claim and say you list a number of orthopedic issues, maybe digestional issues, maybe headaches, those types of things. And what I tend to look at when I look at a rating decision is I first look at when did the veteran serve, what was their years of service, when did they file their claim. So if I see that they served up until September of 2001 and they filed their claim in October of 2001 or January, within a few months of service, usually I think, okay, from a practical standpoint, they're probably getting, out of the service, getting reestablished, getting resettled, and then filing their claim. And they're often told, and it's true, that as long as you file your claim within your first year of service, your effective date for those issues will go back to your date after service. So there doesn't seem to be any sort of sense of urgency in that, which is true, except for just from a practical that's true legally. From a practical standpoint, what I see and try to address is, what do I see the VA doing with that? How can I give you advice on filing a claim to make it the easiest as possible? So generally you want to file and get your paperwork together, and even file while you're in the service. You're able to do that. It won't become effective until afterwards, but if you've got things that are going on, the two key things that are important is exit exams are very important when it comes to identifying those issues or putting them in your service treatment records. Now, I will tell you, one of the biggest complaints that I've heard through the COVID season is a lot of exit exams didn't get done. So that was one of the hiccups, and that's one of the pieces of evidence that we use in arguing that these things should be service connected. So kind of going back to, if you receive a decision that you're going to, and you get a denial, and it's something that you didn't document in service, but you were diagnosed within a year of service, there's some things that we can do, and there's things that you can do to help push that claim forward and help provide evidence that's going to help it happen. This isn't necessarily, I'm going to quote law and verse and statute and regulations. I'm giving you from my experience. So we will address a little bit more of that when we get back. We're up against a hard break. You were listening to The Veterans Voice. This is Amanda Manier. I am your host. I am the managing attorney at Veterans Law Group and a veteran advocate. And one of my favorite things to do as part of my job responsibilities is holding hearings. For one thing, I love to go to hearings and I love to kind of walk a veteran through that process. But in addition to that, it's doing teaching, and I do some teaching with veteran service officers. And then I also feel like that's my job here, and my role here at the Veterans Voice is to answer questions and try to educate the public as well as veterans and their families about what their benefits not only are, but how do you navigate the process to get the benefits that you need. It's one thing to know that you what the benefits are and believe that you're entitled to them. It's another thing to work through the process with the VA. It is an organization that is all about bureaucracy and red tape, and there are certainly great people that work for the VA. I've met many of them, and there are also some struggles. There are some limitations legally. There are some issues with, laziness, honestly, at the VA that I feel like, and lack of communication. I could go on, but ultimately what I look at as my job is I'm representing veterans that are walking through this process, and my job is to put all the ducks in a row and make it very easy for the VA to grant the case. So look at the simple, it's kind of a math formula to me. It's A plus B plus C equals VA benefits. And how do you put those together and make it clear as day for the whoever's looking at for a veteran service officer or veteran service representative at the VA, or a decision review officer who's looking at your case, or even a judge at the Board of Veteran Appeals. We are live here this evening taking your calls, answering questions. We've got a couple of topics that are currently pending, but if you got something on those topics or on anything else, I'm happy to take your call and answer your question. Let's pick up Max in San Diego. Max, welcome to the show. What can I do for you?
Hi, Amanda. Good evening. I have a quick question for you, and then I'd like to get to the one that I made with your call screener. I want to know, sure. I've been waiting 2.5 years now to get a matter taken care of at the board. And it's just a single issue. It's an extra scheduler issue. But like I said, this thing is this, I think you've been saying on the radio for a while now that you're taking about 2 years to get to those. And yet it's just, I get nothing from them. I ask the question, I'll work with my attorney, but they can't get anything from the board. It seems that they are spread really thin, or they're taking their sweet time, or whatever. And it's just very frustrating to wait. So I was just wondering, would you like to adjust your prior statement?
You kind of cut out for a minute.
Okay.
You kind of cut out for a minute. I think you said, would you like to? And then I lost you for a second.
Would you like to amend your statement from the prior?
Well, it does change over time. That is for sure. So I assume if you've been waiting for that long, your case is in the new appeals part of it. It was decided, your claim that you appealed was decided 2019 or later?
Yeah.
Or was it before that? Okay. So new appeals.
We filed in February of 2020.
Okay. So yeah, you're probably right within the same time frame. My other question I would ask you before I thoroughly answer your question is, which lane did you choose at the board? Did you choose direct evidence, new evidence, or request a hearing?
I think it has direct evidence.
Okay, so direct evidence means you're not submitting any new evidence since the previous decision. You're just asking for a judge to look at it.
Correct. That's what we've been waiting for, and they've been saying it's been on the VA's website or one of their portholes, whether it be benefits or va.gov. It's always saying the same thing. A judge is waiting to hear your case, but when they actually are given the case, it's taking so damn long, which is very frustrating,
yes,
to say the least.
Yes, it is. So I will tell you that it changes over time, because the more people. So essentially, what happened with new appeals is, they did not anticipate, the board did not anticipate the number of cases that were going to go directly to them. They anticipated more of them being resolved at the VA level. And so they have publicly said to Nova, who I spoke with, that they were surprised at how many cases asked for hearings, that their hearing requests went up 40%, which they didn't expect, but at the VA level, you lost your ability to get a hearing when new appeals went into. So that got it backed up. And then the more cases, their initial target was, if you were requesting a hearing, you would get a hearing within 365 days. So clearly that's not happening, because the hearing lane is the one that's taking the longest. So I can tell you that I have a direct...
My attorney is just okay, the record is there already. Let us just have you make a decision. That's what we've been waiting for, because it was the board that came up with this extra scheduler issue. It said, we can't resolve this at this time, but we'll come back. And that's what we've been waiting for ever since. That aside, I want to ask a question about what you've been saying for you. I think about a month ago, you let us know that the Supreme Court, you're before the Supreme Court arguing for the benefit of the doubt for veterans when they file claims. I don't really know what level that would be, other than the initial startup, which is based on the veteran's desire to do that without the assistance of an attorney. But they can definitely reach out to the other supporting groups that are there to help them, guide them. So, as you know, should the Supreme Court make a decision, let's say that's favorable to the outcome of what you're petitioning the court for, it doesn't necessarily things will change overnight because we're dealing with a huge bureaucracy.
Right.
I was just asking, what is the anticipation or projected anticipation of the outcome should you prevail? As to what exists right now, obviously there's a problem because the VA is not giving people the benefit of the doubt, at least veterans anyway, when they file their claims. Should you prevail, what will change, and how do you really see this panning out? I'd like to know.
Sure. Without trying to give you what I often refer to as the most common legal answer you'll get from any attorney ever is, well, it depends. We're trying to just give you that answer. It generally does. It depends on what the court says when they decide, it will effectively overturn a case that is currently at the Court of Appeals for Veterans Claims, the Federal Circuit, effectively overturn that, and it'll affect the way the Court of Appeals is treating that doctrine, which will then trickle down to the BVA and the VA. So yes, there will take some time to do that. As to whether or not there's any recourse in the way in which the VA has treated things in the past versus now, it's again going to become one of those it depends things. So for example, we all know about there was a Federal Circuit case that recognized Blue Water veterans as considered being part of being within the Republic of Vietnam. So it was a Federal Circuit case who initially said, you can't do this. You can't say that somebody was not within the Republic of Vietnam because they didn't put boots on the ground. Within the Republic of Vietnam means within their international waters. So they're the ones that changed that. And then before it actually trickled down and actually got implemented, Congress went out and passed a law and said, oh, look what we did, and changed that. So it does take some time to trickle down. And then even when that does happen, there has to be a decision as to whether or not it becomes a retroactive benefit or not. Now, the Niemer case, which is the other one we talked about last week, and Agent Orange people might be familiar with that. The Niemer case is the one that said if you previously filed for a condition through Agent Orange and you were denied, and then we later decided it was presumptive, you now can reach back and get that claim to go through. Whether or not something like that happens with a change in the way that the benefit of the doubt doctrine is implemented is yet to be seen. But right now, everything is filed at the Supreme Court. I had them all on my desk this morning, a bunch of what we call in the legal world amicus briefs. So it's other organizations that are filing in support of our petition, including like Vietnam Veterans of America, some law school petitions, the Federal Bar Association filed petitions in support of our claim, or briefs in support of our petition. So we're crossing our fingers and hoping that the Supreme Court takes it. But if you're unfamiliar with that area of law, the Supreme Court has to make a decision on whether or not they're even going to take on that case to make a decision. So that's the first hurdle before we get to the other one. But how it's all going to play out is unfortunately, it depends answer. Does that make sense?
Yeah, I think one last thing before I go which is I didn't know that the benefit of the doubt had basically devolved to the point where you hear stories about veterans filing claims and then it becomes a very confrontational process from the very beginning. Yes, you can be denied in the beginning, but it seems like people in the past had described when I file a claim, you're going to expect a denial, especially if you don't have your evidence, all your ducks lined up in a row and present the way that you describe it, where you give A, B, and C is what they're looking for, because as a veteran, you don't really know all this stuff unless you're very studied into how to go through that process on your own, or either with and that's why you train the SOs and you train those organizations to get a good outcome for them, especially if there is evidence. But in my time, it seemed like veterans were always sort of at odds with the VA. They wanted to deny you just to see whether or not you really wanted to be in the game or not. And then sometimes that could happen successive times, multiple times on a particular issue or multiple issues. and you seem to be going
Sure.
nowhere, which means you either reach out for an attorney or work studiously with a VSO group and try to make something happen. But I hope that if you guys prevail and benefit of the doubt becomes a reality, hopefully they will unskew what they've done over the years, and it's probably been decades, and give veterans a fighting chance to sort of realize their claims while they're still living, because that has happened as well, where they give up or they pass away.
Definitely.
And now it's just left up to their heirs to try and get those benefits.
Yeah, and as we talked about before we went to break, it's that's one of the legislative initiatives we want to work on, is to help with those dependents being able to, or not dependents, but adult children to be able to take that on. Thank you so much for the call, Max. We are up against a hard break here, and we'll be back. This is Amanda Manier with the Veterans Voice. We are talking about all things related to veterans and working with the VA, specifically related to VA disability claims. We are taking your calls live this evening. We're here at 800-222-5222. If you have a question about your claim or even a family member's claim, you're welcome to give me a call. We've been working in this arena for over 25 years, and while I don't know a lot of things about a lot of things, I know a lot about this. Worked with thousands of cases, and as I was talking before we went to the break, before we took a call from Max, well, I want to address a couple of things that Max said. One, just for clarification purposes, is the benefit of the doubt doctrine is a concept in which it says that given equal evidence, 50-50 evidence between granting a case for the veteran or not granting it for the veteran, it should tip in to the side of the veteran. So give the benefit of the doubt to the veteran that his case should be, or what his side of the story is correct. And in that, as Max was saying, it can become where it appears based upon that, and it appears based upon things like discussing the fact that the VA is supposed to be a non-adversarial process, which means that the VA, the Department of Veteran Affairs, is supposed to be built with an organization that's there to help veterans walk through the process of getting the claims that they are entitled to. They should not be on the side of arguing against the claim. It's not supposed to be at any point in time feel like you're being cross-examined, that you're questioned, that your integrity is questioned, that your story that you're saying is questioned. But I have, as Max alluded to before we went to the break, that's definitely the perspective that a lot of veterans get, or experiences that they get when they feel like they are filing a claim and they feel like they're being questioned and that the benefit of the doubt is not being given to them. So again, the benefit of the doubt is when there's equal evidence. You have to support one or the other. It's not just, okay, we're going to give the veteran the benefit of the doubt. No matter what he says, we're going to believe him or her. It's when there's equal evidence. So where some of that conflict comes in with where I've sat in a room with decision review officers, not necessarily with veterans law judges. That's rare. Veterans law judges are those who are deciding at the Board of Veteran Appeals, which is when you appeal your case up to the board outside of the VA. I've sat in a room with decision review officers and reminded them that this is a non-adversarial process and that we're all supposed to be on the same side to do what's best for the veteran, and do not just what's best for what's best for the veteran under the law. We all have to work within what is legally allowed by regulations and statute to grant those benefits, but we're supposed to be working together to get that veteran what they need. And unfortunately, sometimes it becomes a little bit of a battle in order to get that. And I hate that veterans experience that. It's not supposed to be that way. It's not supposed to be where you have to prove yourself. That generally it should be as simple as the math formula I alluded to. It's that you have an in-service injury, you have a current diagnosis, and there's a link between the two, and therefore you're service connected. And then the only thing after that is to determine to what level or what severity. But there comes to be, in my experience, a question a lot of times of, if there is nothing in your service treatment record of that in-service injury, how do you show the VA that happened? And I find it interesting that one of our earlier callers was talking about how they were able to prove some things based upon love letters with his wife. I've had some of that same experience of a letter that was sent to one of our clients, or letter sent by one of our clients when he was serving in Germany to his wife many, many years ago. And we were trying to pursue an ankle injury that he had, and they didn't have anything to serve his treatment records, and some of his medical records were lost. But there was a letter that he had sent her that talked about that he had hurt his ankle and that he was on crutches. And so we utilized that, and we took that to the board, and we were able to get it granted. So again, kind of going back to that, it's not supposed to be adversarial, but it certainly feels like that at times. And that's why I go back to always saying, don't do this process alone. Don't file your claim and represent yourself alone, because while the VA is supposed to be there to help you walk through the process, if you work with a representative whose sole intent and sole, loyalty is to the veteran and has done thousands or hundreds of these cases, and again, it's not about necessarily dealing with what the letter of the law is. Sometimes it comes down to, well, sure, that's the letter of the law, but this is how we've experienced getting things through the VA. So that's kind of how we approach things. Again, we are taking your calls live this evening. This is Amanda Manier with the Veterans Voice. You can reach us at 222-5222. That's 800-222-5222. I'm happy to answer your questions or just have a discussion with you about what's going on with the VA. I will say that I'd like to dig in a little bit on this topic. We'll probably take another show to dig in it a little bit more, but it's such a hot issue that's been going through for a long time, but for some reason I've seen a spike in it lately. And that's when it comes down. We talk a lot about PTSD. We know that generally when you think PTSD, it's usually military related. It doesn't always have to be. But there are a lot of other mental health issues that come up for veterans, or diagnoses of mental health that come up for veterans, that makes it a little bit more difficult to navigate with the VA. One is still PTSD, but it's non-combat related. So there are some other kind of rules that you need to follow, things that you need to show. The VA effectively has to, so let's make this simple. If you file a claim for PTSD and you are in combat, they're going to presume that, and you get a diagnosis of PTSD because you have to have that current disability, or that current injury. They're going to presume that it's related to your combat. You don't have to go in and write a letter and say, I have a stressor number 1, stressor 2, number 3. There's a form that you fill out. You don't have to do that if you were acknowledged by the VA to be in combat. The non-combat stressors are those in which they may be a training accident. It may be, unfortunately, the one that I'm thinking of that came up this week was they saw a fellow military member commit suicide, and so that they were not in combat. They were at home on the base. This happened. And that is considered a stressor to trigger PTSD. Well, in those non-combat related situations, you're required to fill out a form that says what the stressor was, where you were, where you served, who that person was, and then they want to, what they call, corroborate that stressor. So you have to tell the story, and then they will do some research. You generally have to give them a time frame. They've asked at this point to be in 60-day blocks, so maybe you don't remember the exact day, but it's a period of time where they can do some research as to, can they corroborate that stressor by military records? If it's on the Navy, can they corroborate it by deck logs? They're going to try to do that, and they're going to go through the National Archives and look through the research. I will say that sometimes they're great at finding things, but a lot of times they aren't. So we work with particular companies and people who will go to the National Archives and do research for us if we can't get it corroborated. But even if there's nothing to corroborate it, that used to be an old school thought. When I was originally taught VA disability law, it was, oh, well, you can't corroborate the stressor. That's going to be a tough case. Or, oh, no. And I have gotten over the years to, I don't care if there's anything, if the National Archives can't find anything, nothing on the deck logs, nothing anywhere. Your best bet is your own personal testimony and credibility, and that's under testimony before a judge at the BVA, at the Board of Veteran Appeals. So when I see a case that comes across my desk like that, where the veteran is unable to, or the VA is unable to corroborate a stressor that happened, so again, something non-combat related, then I will appeal that case right all the way to the board immediately, because I want to get it in line at the board. As we heard from our previous caller, the time frame for getting your case before the board is getting longer and longer as cases build up at the board, now that they have streamlined things at the VA level and the appeals department. Get it up there, get it on appeal. And I'm requesting a hearing because I want the veteran's own testimony before the judge. I want the judge to see that person. I want the judge to see them as a real person, hear their story, and decide at that point whether or not they believe their story. So there's a concept also within the VA or the VA world working in, is that lack of medical evidence or lack of evidence doesn't mean that that never happened. So lack of a corroboration of your stressor does not mean that it did not happen. And that opens up even more for their opportunity for them to accept and review and listen to lay evidence, which lay evidence is going to be your testimony at a hearing. Lay evidence is going to be the letter you wrote to your wife while you were in service. Lay evidence is going to be, say in a military sexual trauma case, it might be testimony or a letter from your mom who saw a difference in your behavior from before the incident to after the incident. So those are cases in which I go directly to the board on, but non-combat stressors can create a little bit of a extra struggle and hurdle. But if you're one of those people who are dealing with that, do not give up. Contact our office. We will help you. Our number is 888-811-0523. I am Amanda Manier with the Veterans Voice, and I will be here next week at 7 o'clock every Tuesday evening from 7